I'll be discussing the case of Avel Proprietary Limited against Multicoin Amusements Proprietary Limited. Avel Proprietary Limited entered into a distribution agreement with Williams Electronic Games Incorporation, who were a manufacturer of pinball machines. And as manufacturers of pinball machines, Williams was the owner of the artistic work displayed on the machines and the computer programs which ran them, therefore owner of copyright of an artistic and literal work pursuant to the Copyright Act. Multicoin Proprietary Limited were importers who were interested in importing used Williams pinball machines into Australia from two separate American distributors. When Avel found out, they threatened to take legal action against Multicoin for infringement of copyright. Multicoin then instigated proceedings against Avel pursuant to Section 202 of the Copyright Act, alleging that the threats made by Avel were unjustifiable and sought an injunction to refrain Avel from making any further threats. However, Avel counterclaimed, arguing that their actions were justifiable because the distribution agreement gave them the exclusive right to publish the pinball machines in Australia and therefore made them an exclusive licensee of Williams' copyright. So what was the decision of the High Court? So one of the first issues considered by the High Court was whether Avel had an exclusive license. The High Court held that the distribution agreement did not make Avel an exclusive licensee of the copyright in the artwork and the computer programs. Avel tried to argue that the distribution agreement gave them the right to publish, which is an exclusive right in the copyright, pursuant to Section 31 sub 1. Prior to this case, the meaning of publish was not exactly clear. Avel relied on Section 29 sub 1 to define publish in Section 31. Pursuant to Section 29 sub 1, publish amounts to supplying, by sale or otherwise, to the public. Avel relied on Section 29 because the distribution agreement gave them the right to sell or resell, advertise and promote certain machines. Therefore, if Avel were able to establish that publish under Section 31 means the same as supply to the public, then the distribution agreement would have provided Avel with the exclusive right to supply the pinball machines to the public in Australia. However, following on from the decision of the House of Lords in Fabrics against JTech shirts, the High Court held that the publication means first publication. Accordingly, the definition of publish pursuant to Section 29 sub 1 of the Act does not apply to Section 31 sub 1. Therefore, the exclusive right to publish means to make available to the public in Australia something which has not previously been made available. The only rights given to Avel in the distribution agreement was the right to sell or resell, advertise and promote, and not the exclusive right to make public in Australia something which has not previously been made available. Therefore, the High Court concluded that Avel were not an exclusive licensee of Williams' copyright and were not entitled to any relief against Multicoin for infringement of copyright. The next issue to be considered by the High Court was whether Avel's threats to take legal action against Multicoin for infringement of copyright were justifiable under Section 202 of the Copyright Act. In order to establish this, the High Court held that the onus was on Avel, the party alleging infringement of copyright, to establish that Multicoin would have infringed Williams' copyright by importing the artistic and literal work into Australia without the consent or license of Williams pursuant to Section 37 and 38 of the Copyright Act. However, due to a lack of evidence, the High Court held that Avel's threats to Multicoin were not justified because Avel could not establish that the importation of Williams' pinball machines by Multicoin for the purpose of sale would have been an infringement of Williams' copyright pursuant to Section 37 and 38 of the Copyright Act. Therefore, Avel's counterclaim was dismissed.